Good afternoon. I'd like to welcome you to this week's webinar presentation. My name is Kathy Purdy and I'm the Marketing Manager here at Schoeneck King. Just two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Once today's presentation has ended, we would appreciate it if you would take a moment to complete the survey. We appreciate your responses and share those as well as suggestions for future topics with our presenters. So with that, I'd like to introduce today's moderator, Andy Bobrecht, to get us started.
Great. Thanks, Kathy. Good afternoon, everyone. Great to be with you today. Looking at the calendar, hard to believe it is the middle of June already. Time is going quickly. Over the past week, we had a number of notable developments that we're going to present on today for you. Most of all, COVID related, as we continue to see the opening up of our economy and the lessening of restrictions across the board impacting employers and businesses here in New York and elsewhere. As we've reported previously, and by the way, we've got a great panel today. Once again, I think you'll be interested in everything our folks have to say here. At the end or near the end, I'll try to address some of the questions from our mailbag too. As many of you will recall, we've been tracking several different lawsuits, which were in some substance challenges to employers requiring their employees to obtain a COVID vaccination. One case in particular in the Houston, Texas area, we had our eye on involving a hospital there. Today, we have Mallory Campbell from our New York City office. Mallory's been tracking that that lawsuit, and has a report for everybody today. Mallory, great to have you with us, and take it away.
All right, thank you, Andy, and thanks everyone for tuning in. So one issue that I know everyone's been thinking a lot about is the COVID-19 vaccine and whether employers can create a policy that mandates their employees to get the vaccine. So we haven't seen a federal case on the COVID-19 vaccine yet, but we have seen cases prior about mandatory vaccination policies for the flu and for other diseases. So typically those previous cases were in the healthcare setting, and they were usually employers that mandated employees to get the flu vaccine. And those cases were typically decided along the lines of upholding mandatory flu vaccine policies, as long as there were exemptions for religious or medical reasons. But now we have the first federal ruling for a COVID-19 mandatory vaccination policy. And this case was decided along similar lines as those previous flu vaccine policy cases. So as Andy mentioned, it involved Houston Methodist. This is a hospital system, and it required all of its employees to get the COVID-19 vaccine. After months of warning its employees to get the vaccine, it placed more than 170 employees on unpaid suspension and told them that they would be fired if they didn't get the vaccine by June 21. 117 of those workers filed suit against the hospital in the Southern District of Texas to block the vaccination requirement and the terminations. The lawsuit argued that Houston Methodist is unlawfully forcing its employees to receive the COVID-19 vaccine or be fired. The bulk of the plaintiff's arguments was that the currently available vaccine is, quote, experimental and dangerous and against public policy. In its decision, the court made reference to recent EEOC guidance published on May 28, which stated that employers can require employees to be vaccinated against COVID-19, subject to reasonable accommodations for employees with disabilities or sincerely held religious beliefs. The judge dismissed the lawsuit and had some pretty harsh words for the lead plaintiff, saying her claims are false and irrelevant. The judge explained that the plaintiff can freely choose to accept or refuse a COVID-19 vaccine. However, if she refuses, she'll simply need to work somewhere else. Based on the EEOC guidance, as well as this Houston Methodist case, it appears that employers should be able to mandate the vaccine as long as they provide for religious and medical exemptions to their employees. So we'll keep monitoring this case and others and track whether employers in general start mandating more of the COVID-19 vaccine and keep you updated. And that's all I have. So I'll pass it back to Andy.
Thanks, Mallory. It was an interesting decision for sure. Pretty short, direct and to the point, and I think notably refuting the claim that somehow the emergency use authorization tied at employers' hands in requiring the vaccination. I think we'll see more likely litigation in this area, but I think this is really the first, if I'm not mistaken, right? This is the first decision that we've seen that definitively addresses this issue.
Yeah, the first federal one for COVID-19.
Do you have any thoughts for clients and friends of the firm who are on the webinar here, who are giving thought to whether they want to or should implement a mandate for vaccination?
I think it's something to keep our eyes on and see whether this starts to become a trend. I think we'll see more lawsuits like this, and I'm curious to see if they'll all follow along the same lines. But definitely, if you're going to have a policy like this, you have to have these exemptions for medical and religious reasons.
Yeah, and I think it was notable too, right, that this was a hospital. And of course, the concerns are heightened with respect to exposure and your employees and keeping members of the public and your patients healthy there too. I think the guidance that we've been giving and the advice that we've been giving thus far is you really have to look at this with respect to your individual business or organization. How extensive are your interactions with the public? What kind of space do you have? How close do people work with one another? And what's the impact on your staff and your operations too? And I think it's still, notwithstanding this decision that certainly provides some insight onto how this would be addressed. Of course, this was just a court in Texas, and you're going to want to work with your bond attorney, make sure that you're comfortable and understand any legal concerns, including, Mallory, as you noted, with respect to the accommodation issue for disabilities and sincerely held religious beliefs. So continue to work with your bond attorneys on those issues too. So thanks. We'll have you back, Mallory, if there's anything else to see on this front. Appreciate you joining us.
Sounds good. Thank you.
All right. Up next, we have Nyla. Nyla is going to join us and talk today about a very significant development that we saw just recently, that being OSHA's publishing of an emergency temporary standard. This has been in the works for many months. This was a priority of the Biden administration before day one of the administration. The standard that came out was more limited than initially expected, specifically focused on healthcare areas. It should be noted this is not necessarily just limited to hospitals, and there's other guidance that OSHA has put out too. There's a lot to this. I expect we'll have additional further presentations on this and potentially a separate standalone webinar program for our clients on this issue. But we wanted to take some time today to have Nyla talk about the standard, what we've been able to pull out and glean from it so far. So Nyla, thank you very much for joining us. We're glad to have you today.
Thanks. So Andy, you're right. OSHA certainly delivered last week. They gave us 916 pages of, a text to read through, frequently asked questions, model forms, and just a ton of information that they kind of threw at us. So first slide, please. The emergency temporary standard is effective immediately. Interestingly, this is the first one since 1983. The last one talked about asbestos exposure in 1983. So OSHA's been, this is kind of like the first emergency temporary standard in a long time. It's effective immediately upon publication in the Federal Register. Employers have healthcare employers and employers in healthcare settings have 14 days to comply with most provisions. There is a 30-day kind of compliance duration for meeting requirements such as physical barriers and ventilation and training. OSHA can enforce this standard with citations and monetary penalties. Usually, like willful citations can be around $135,000 or so. And, it depends on what OSHA wants to do, but it is pretty significant It remains in effect until superseded by a permanent standard. Usually OSHA's standard making processes require that to be within 16 months of an ETS. One of the things that OSHA has stated is that if it decides that a grave danger from COVID-19 no longer exists, then it'll start looking at updating the ETS. Or if new information shows up, it'll again start changing or tweaking the standard. So like it or not, we're going to have to live with this for the next 6 months or and beyond. Next slide, please. So who does it affect? It is mandatory, but to whom? And like Andy said, it is kind of limited in scope, but it's limited to and applies to healthcare settings, healthcare workers, and healthcare support services who work in settings where individuals with COVID-19 are reasonably expected to be present. And there's a lot of examples that they've provided, from hospitals to nursing homes to assisted living facilities. One of the interesting things, and this might impact other employers, is that if you have, say, a medical clinic in a manufacturing facility, you then have a healthcare setting that's embedded within a non-healthcare setting. And then the standard applies to you as well. And then if you have emergency responders or licensed healthcare providers that enter a non-healthcare setting to provide services, it applies to employees in those employees only. Similarly, in the non-healthcare setting that I had spoken of before, the standard applies to only that particular medical clinic or that particular healthcare setting, not the entire non-healthcare setting. Next slide, please. There are exceptions, which is a good thing, but the exceptions also come with different nuances. You will find that a lot of focus is placed on screening, and if employees are screened or non-employees are screened, or if employees are vaccinated, then those settings kind of are able to perhaps apply under these exceptions. So for example, if you're a non-hospital ambulatory care setting, you're like an outpatient service, and all non-employees include your customers and your third-party contractors, and they're screened prior to entry. And you also have a process where people with suspected or confirmed COVID-19 are not permitted to enter, then your setting could be exempted. Similarly, in hospitals, if you have well-defined hospital ambulatory care settings, and well-defined is very important, where all employees are fully vaccinated, you have a well-defined space where these non-employees are screened, and people with suspected, confirmed COVID-19 are not permitted to enter, then you too could be exempted for that particular well-defined setting. Healthcare support services, importantly, like, certain hospitals have offsite laundry or offsite medical billing facilities. And if they're not performed in a healthcare setting, healthcare meaning where a licensed healthcare provider provides medical services to an individual's well-being, then that particular service could be exempted. Otherwise, you do have to prescribe and comply with this standard. The dispensing of prescriptions by pharmacists in retail settings, telehealth services, first aid performed by an employee who's not a licensed healthcare provider, all of that is also exempted. OSHA has very helpfully provided you with a flow chart. You can go take a look at that, and I've inserted a link as well. Next slide, please. So you'll see it has like, it's kind of like this thing where you need to go through and decide, okay, where do I fall? It seems simple, but not so much. Interestingly, one of the things that they do say is that if you do decide to want to be exempted, and you're looking at employees that are fully vaccinated, you must make sure that you have a COVID-19 plan, and that plan has to have policies and procedures that determine your employees' vaccination status. So there's a lot of heightened awareness and encouragement around vaccination of your employees. Or next slide, please. One of the big things that came out of this standard is what's called MRP, Medical Removal Protection Benefits. Now, what is medical removal? And you're required as a qualified employer to remove an employee from a workplace when you know that the employee is COVID-19 positive. You've been informed by the health provider that the employee could have COVID-19. And here's the clincher, like the employee could be experiencing a recent loss of taste or smell with no other explanation, has a fever, and a new unexplained cough associated with shortness of breath. Then too, you would be obligated to remove an employee from the facility. And they do have other things like, if an employee has come into close contact with someone who is COVID-19 positive, provided they have not been fully vaccinated, then too, you wouldn't need to remove them. Interestingly enough, if you have 10 or fewer employees, no payment is necessary. But if you have between 10 and 500 employees for week 1 and 2 after removal, you do need to pay regular pay up to $1,400 per week. And week 3 onwards, if that's needed, you do need to pay 2/3 of regular pay up to $200 per day. That's roughly around $1,000 per week. 500 or more employees, you need to pay regular pay salary up to $1,400 per week for the entire period of removal until the standards return to work criteria is met. You have to make sure regular benefits like health care insurance is maintained. And you have to, other things like benefits that they have is just make sure you provide reasonable time for vaccinations and vaccine side effects. And you're not allowed to terminate an employee or permanently fill their position. The standard specifically states in its frequently asked questions section that you're supposed to fill that with a temp employee. And you have to restore the job back to the employee who has been medically removed. If you, for businesses fewer than 500 employees, you might be able to access tax benefits under the American Rescue Plan. Now, I believe that those are available for leave taken between April 1st and September 30th of 2021. You might need to look into that as well. There's a potential for that. Next slide. One of the other highlights is the reporting requirements. You're supposed to report each work-related COVID-19 fatality within 8 hours of learning of that fatality. You're also required to report each inpatient hospitalization of any employee within 24 hours of learning of such hospitalization. Those are a few more stringent reporting standards than what you may have been accustomed to. If you have more than 10 employees, there's a very helpful COVID log that you can use to track all employee instances. So other than the usual standard OSHA record keeping that you are required to maintain, you also will be required to maintain this COVID-19 log. There is also a sample employer notification tool that the standard provides to you. You're required to notify your employees about potential COVID-19 exposure. Next slide, please. The standards, the OSHA's website kind of has this sample COVID-19 log and information on notification and how you should do it in terms of language you have to use. I've just put that out there. There are excerpts and snippets. You will have to look at the website for extensive details or talk to us about reviewing your COVID-19 logs and your notification requirements. Next slide, please. More highlights. So I talked about the COVID-19 plan, and your plan has to be in writing if it's for more than 10 employees, but you do have to have a plan regardless of the number of employees you have. It has to be in writing, written format if it's more than 10 employees, 10 or more employees. You have to have a designated safety coordinator. The standard describes exactly what the safety coordinator needs to do and their kind of qualifications. You have to do a workplace specific hazard assessment, and you do need to include non-supervisory employee involvement, either via outlets like focus groups or questionnaires or meetings. You need to make sure you involve your employees in that hazard assessment process. And as I had mentioned before, you do have to have policies and procedures, and specifically around how are you going to make sure that you know who has been vaccinated and who hasn't been, which is a tricky area. And we've talked about that before, about if you can ask if an employee can or can't be, is or is not vaccinated. We do have to have patient screening and management. So there are some screening processes, including a screening tool that the OSHA website includes. It provides you a format of how and what questions you need to ask to screen employees and non-employees. Personal protective equipment and those requirements. You need to implement specific aerosol generating procedures for those who are confirmed or are suspected of COVID-19. And then also train your employees on it. Next slide, please. So finally, that is, I think I got done with the emergency standard that is mandatory for healthcare workers in a healthcare or healthcare support services setting. But OSHA also last week updated general guidance for all other employers. There's a link provided for that. It's voluntary, and OSHA wants it to be, helpful to employers and workers not covered by the ETS. Again, it focuses on the protection of unvaccinated or otherwise at-risk workers, encourages vaccination, and asks employers to provide paid time, consider paying employees to get vaccinated, provide free face coverings or respirators to unvaccinated employees, implement physical distancing requirements for unvaccinated employees, and then train and educate employees on COVID-19 policies. Next slide, please. So I wanted to kind of touch base with you on this interesting development that came out of OSHA. It's not related to an emergency temporary standard, but it kind of demonstrates OSHA's actions or claims regarding assuring pandemic safety and COVID-19 and addressing a COVID-19 issue. So in this instance, and this is applicable to all employers in general, an employee raised concerns to company management that in-person attendance at a March 2020 staff meeting could lead to transmission and contraction of COVID-19. So the worker said, you know what, I can only do this remotely. I don't want to meet in person. The health center, the community health center of Richmond, they basically said, we need you to show up for this meeting in person. And later, the employee was suspended and terminated. So OSHA filed a complaint with the Eastern District of New York and stated that, the employer is discriminating in violation of the OSHA Act. They're asking for lost wages and punitive damages. Well, I mean, that's kind of a quick update. OSHA is nothing but ambitious with this, and you can kind of see where their head's at with this. But I wanted to kind of put that out there because that's a very interesting development in terms of what OSHA is looking at right now. And that's all I've got.
Nyla, great. Thank you very much. I know there was a lot there to unpackage. We appreciate the update. Again, folks, we'll push these slides out to everybody. We publish these recordings of the webinar as well as the slides on our website, so you can get it there too if you need to. Good reminder on this case too, Nyla, that if you have an employee who is raising her or his hand with respect to a safety concern focused on OSHA, I think it's a good time to hit the pause button, carefully evaluate the situation, certainly before taking any type of adverse employment action, and to work with your legal counsel as well on that front. We got a lot of questions, as you might expect, about the ETS. I did want to, and I think you covered a lot of them. One question that continued to come up was the requirement that employers provide paid time. I know this caught all of our attention and led to some questions that I think remain unanswered in terms of OSHA's authority to mandate paid leave on the part of private sector employers. I think that is an issue that will continue to receive attention. But just to clarify, the question that kept coming up was whether or not that paid leave requirement would apply across the board to employers, or only those who are covered by the ETS?
Those who are covered by the ETS.
Okay.
Is
all right.
What,
so,
you know.
And I saw the flow chart too, and it's great that you included it in the deck here. Admittedly, it made my head hurt a little bit trying to go through the process there. And I think it's, it's one that the government put together. It's not necessarily entirely clear. There's some vague definitions and terms that are in there. And what would your recommendation be to an entity that is concerned about whether or not it may be engaging in healthcare operations, or part of it is engaged in healthcare operations?
Well, I think OSHA, and we didn't cover this, has defined what healthcare services are and what healthcare support services are in the extensive ETS, and we kind of need to look at that. I think it's almost just kind of a case by cases kind of evaluation. It's kind of easy. It seems very simplistic to go through the flow chart and go, oh, well, you know what, I'm exempted from this process. But I think there is a real need to look at, am I your healthcare provider? For example, if you are an optical, you have an optometrist on site, and you're a retail optical provider, or, you could be a nurse's office located within your company. You kind of have to look at those particular areas to see, well, do I fall under this exception? And even if you fall under those exceptions, you still have to make sure that you're screening non-employees. You have a process to make sure that you are preventing those with confirmed or suspected COVID-19 from entering your workplace. So I think there's layers to that. Yeah. I think, like it or not, we have to have some sort of process or policy built around that.
Yeah, that makes sense.
Yeah,
and I agree with you. And I think, what I would say is, if you have concerns, that being the attendees here, reach out to your bond attorney. We can give you an assessment on coverage, where you think the standard applies to your entity, organization, or part of it or not. And the reality is, you're just going to have to work through those issues. And I'm sure this is, we're getting this standard now, a year and so many months into the pandemic. And I anticipate, this is in some ways frustrating. Certainly the intents are good behind it, to keep people safe, keep healthcare operations safe. And my hope is that too, for those entities who are covered, that much of what is in the standard are things that you're already doing and have been required to do either through New York State or that you've been doing as a matter of best practice. But at the end of the day, now you'd agree, you're going to have to take a look at what you're doing currently and what the standard is saying and make sure that you're complying for the time being.
I would say, Andy, you focus on the fact that, okay, I do need to comply, and then kind of review how you can kind of draft your policies and procedures and systems in order to fall under some of those exceptions. That might be kind of like the way to go. You have to have some sort of written or documented kind of process for that.
Isla, thanks a lot. We'll have you back, I'm sure, at some point. Appreciate you joining us. Okay, I was going to go next, but why don't we have Katie Anderson go? Katie's been monitoring some developments in Albany. She'll have kind of her usual information to share, and we saw a lot of activity of late too. Katie, how are you?
I'm all right. How are you, Andy?
I'm good, thanks.
All right. Yes, I was. I wanted to go out of order today because the governor was speaking and is still speaking and began speaking at 12:15. So I figured worthwhile to have me listen into that for a little bit so I can update all of you on what's happening. So first, let's start with what we do know. If I could have the next slide, Kathy, thank you so much. Again, in New York State, we continue to see our numbers be extremely low in terms of the rates of the virus across the state. Excellent news. Vaccination progress. All New Yorkers, we've reached 50% of all New Yorkers are fully vaccinated, and 58% have received one dose. 18 and older, 62% are fully vaccinated, and 70% have received one dose. As a result of that, we saw these. This is why the governor is currently giving an announcement as we speak. But before I go into what the governor said, worth taking a look at other states. Just really quickly, New York is 15th in terms of people who have received one dose, but is around the top 10 for people who are fully vaccinated, above 18. Not all New Yorkers, but everybody 18 and older. You look at this concentration of states, it's really, the Northeast and then certain parts out West. So again, good news all around. And we get to this question, a question I've been trying to figure out myself. We got to 70%. Now what? So the governor is announcing today, currently, quote, that all COVID restrictions are being lifted. So effective as of whenever the executive order comes out, you will not need to use those reopening guidance documents unless you are in an industry like education, so schools, K through 12 schools, healthcare facilities, public transportation, correctional facilities, and even camps and daycares. You still need to continue to follow the guidance documents that are out there. For everyone else, the guidance documents are now just that, guidance. You can use them, but you don't need to follow them. What does that mean? It means that, for great news, I'm so thrilled to be the one to announce it to you, but as soon as whenever that executive order comes out, say goodbye to that health screening questionnaire, say goodbye to the signs on the floor that say how far to stand apart, say goodbye to the signs that say social distancing needs to be maintained. One issue that still hasn't been resolved because the governor didn't go into detail during this announcement is, what are we supposed to do about unvaccinated people and masks? Stay tuned on that. It was unclear in his announcement what is going to be happening with unvaccinated people and masking. He said that the state would continue to follow the federal guidance on that. To me, that indicates that we are going to remain constant with the guidance. Unvaccinated people will need to continue to wear their masks and social distance. But again, it was very unclear in this announcement. He really only spent about a second going over it. So I wish I had more details to give you on that. Social gathering restrictions, gathering numbers are lifted. So as of whenever this executive order will come out, there are no more restrictions on gathering limits, either inside or outside. Unclear, large event venues will likely need to continue to follow the unvaccinated guidance that came out, the mask guidance that came out on May 19th. But really, I'm left with a lot more questions than answers. I'm sure many of you are also left with a lot more questions than answers, but for certain, for certain, we will be, looking at the change in the health screening, all of those things that came through that guidance, those reopening guidance documents. We know that's going away. So that is good news for us all. And we, might as well focus on the things that we know right now than the things that I don't know at the moment. Andy, I see you unmuted. Do you have a question?
No, not at all. Thanks. I know we're getting a lot of questions from people about the impact of the governor's announcement and how this affects their particular business or industry. And I think people, this is, again, more information will be coming out. Katie, I expect, you tell me, I think we'll see an executive order at some point in the fairly near future. And I'm sure you'll tell me that you'll be working with others here to push out guidance, provide insight to people about what the practical impact is as broadly as we can. But at the same time, you're probably still going to need to take a look at your individual business or organization because it may not be painted with such a broad brush. Fair to say on those points?
Exactly. Yeah, exactly. It's we still have a lot of questions, and this is about as breaking news can be. So once we have more details, we will be sure to get those out to you all. And keep your eyes on the governor's page, keep it on the New York State page, and keep it on our website as well. We will be updating you on what's happening. Turning to another place that we're looking at some information that's, we don't really know what's going on there either. Lots of you again ask about the Canadian border reopening. Really, the talks between the United States and Canada have failed to produce any solid results over the past week. So it appears that the border will continue to remain closed, except for fully vaccinated Canadians who are returning to Canada. They can fly out of Canada, but they can't drive out of Canada. They no longer need to quarantine upon returning. So again, stay tuned for more information on that. I know lots of people are, getting really angsty about trying to get that border reopened. And finally, I could have spent the whole webinar just talking about the end of the legislative session, but the New York legislature, they ended their session last week. They passed 634 bills in a 2-week period. We did see the HERO Act passed. It was signed by the governor on Friday. This means that by July 4th, the Department of Labor will need to have produced the model plan. So keep your eyes out. We will also be keeping our eyes out for that, just to give us all some more time to deal with the HERO Act. Paid family leave. There was a change in the law. This hasn't been sent to the governor yet, but it will add siblings to the definition of family member for the purposes of paid family leave. There was also the expansion of whistleblower protections, looking at independent contractors and former employees. And then finally, prior written notice will need to be provided to all employees if any type of electronic monitoring is occurring. So those are some of the, really quickly, some of the bills of the 634 that passed in the past 2 weeks for you to take a look at. Next week, there's a good chance I'll be going through even more bills that came out. But one other thing to note as well, I know that we're getting a lot of questions still about what's happening with with COVID restrictions in New York. And it's worth pointing out the state of emergency is still in existence in New York State. That's not going away. I really don't think that that's going to go away for a while. We are still in the middle of a pandemic. Despite having great vaccination numbers in the state, scientists really say that, you know, we really need to be closer to 80% before we're in the clear. So this will constantly be evolving, but we will be with you every step of the way. So I'll kick it back to you, Andy.
Katie, thanks a lot. Appreciate you keeping your ear to the rail and being able to respond so quickly to things that are developing as we are presenting here. I think it's reminiscent to me of when we saw the CDC's guidance on vaccinated people being able to unmask, and then a press conference or press release from the governor's office about adoption of that principle, and then kind of this uncertain period as to what entities and employers and others operating in New York should do. I think my view, and I think it's shared by others here too, is you know, I hear questions, can we eliminate the mask requirement now, or the screening right now, take our signs down right now? Can we rely on the press release? Do we have to wait for the executive order? And I would just encourage folks to just wait just a little bit. I understand there's a strong desire to open things back up, but I think you also want to make sure you're comfortable doing so and that you have full information. And all things being equal, I wouldn't, you know, be hard pressed to recommend relying on a press conference or a brief statement there. There will be more information that comes out from the state. We're going to look at it very carefully, and we will get guidance out to all of you and to our clients as well on these points. So, and likewise, I'm getting questions from people who say, well, you know, we're just not comfortable eliminating all of these procedures and safeguards that we have in place. And that's understandable and appropriate too. So I think, again, you have to evaluate what works best for your organization and make the decision that's right for you. And that could be leaving some procedures in place.
And it's worth noting too, we've seen the governor make announcements throughout the pandemic, big announcements in press conferences that are actually, they turn out to be much narrower in, you know, effect. So we'll keep our eyes out for that. You know, I have some concerns about that. So please, you know, just everybody be a little patient. We will be getting those answers out as soon as we have them.
Great. Katie, thanks a lot. I appreciate it. I'm sure we'll have more. All right, we have just a couple minutes left. Why don't we go back to our mailbag here? A few things I wanted to just touch on. I'll try to get everybody done here shortly. So the HERO Act, I know we had a lot of questions about that and what's required on the part of employers here in New York. There were technical amendments. Those were just finally fully passed, and as of, I believe, Friday, signed by the governor. And the question that we're getting is, well, when do I have to be concerned about this? What are the deadlines? We know there's things that we need to do. Here we have a bit more breathing room, and there's, of course, two components to this. The first part that I think is most pressing and on people's minds are the Airborne Infectious Disease Control Plan and procedures that we need to have in place. So this statute, based on the technical amendments, is not effective until July 4th. And compliance is going to be triggered on when the state publishes its model standard. I don't know when that'll happen. It hasn't happened yet, to my knowledge. And I was on the Department of Labor's website earlier today, and I couldn't see anything there that it's been published. We'll let you know, I promise, when it is published. We'll get that information out. But again, it's going to be triggered 30 days from whenever that information is published, that standard is published from the state. That's when the employer has to adopt their own plan. And then there's an additional 30 days that the employer will have to push that information out to employees. So I think we're talking probably end of summer when that process will be complete, but stay tuned on that front. The other piece dealing with the labor management workplace safety committees, that particular piece is not effective until November 1st. So again, plenty of breathing room there. And we don't read the legislation as requiring employers to take some affirmative step to create such a committee. Rather, it provides a process that if an employee raises her or his hand and says, hey, I'd like to form this committee, it prescribes a process that the employer would need to follow with respect to the establishment of that committee. We, of course, would encourage you to work closely with legal counsel if that comes up. I think we covered the paid time off issue under the ETS standard extensively. Again, I think there's some question there in terms of the scope of OSHA's authority to require employers in the private sector to provide that paid time off. But again, that only applies to entities that are covered by the ETS. If you have specific questions beyond that, I encourage you to work with your attorneys. We're seeing a number of clients who have allowed employees to work remotely, and they're starting to bring their workforces back. And the question that arises is, can we withdraw, let's say, a previously approved remote work arrangement? Again, absent some kind of contractual obligation that you may have as the employer to do so, the short answer is yes. But again, you're going to want to be careful and be thoughtful about the approach there and the impact on your business and your organization. But the short answer is there, yes, circumstances are indeed changing, and so can your flexibility and willingness to provide remote work. Just keep in mind, it's something that many employees are enjoying and have, at least in the polling data and other survey data that I've seen, expressed a strong desire in many instances to continue doing so. Daily screening, I think Katie covered that already. We'll have to see exactly what happens. That is something that could be lifted for many industries and areas as part of us hitting the magic 70% threshold. For now, I think prudence would dictate following whatever the New York Forward plan for your particular industry states and continuing to do so until you get comfortable that, okay, indeed it is the time now to for us to not have to ask those questions and take those other steps based on clear guidance from the governor's office and from the state. And then finally, I'm hearing some instances where PSL that has been provided under state law is being exhausted, and what do I have to do after this point? Well, if it's exhausted, the short answer is it's exhausted. If they've used all that time, you don't have an affirmative obligation to provide additional time off for qualifying PSL reasons, but keep in mind there could be other leave that an employee is eligible for, including COVID-related leave, if they're subject to a governmental quarantine order or if they're seeking vaccination. There could be additional buckets of leave as required under state law that employees could still be eligible for. So just don't forget about those as well. All right, that was a quick run through our mailbag. I want to thank everybody for attending today. Thank all of our presenters. We covered a lot of great information. Again, we'll push these slides out so that you get them. If you have any questions in the meantime, please let us know. Thanks, everybody.